Good evening, everyone, and welcome to today's session. We are going to discuss today mostly in terms of it's a very interesting topic today, which is related to counter claims. So the topic goes take down notice against you. So if it is a take down notice against you, then what exactly you need to do, how to deal with them, what are the steps you need to take care of, uh, how we are going to see how you can restore it if it is a false claim. So all this information, uh, today we have a wonderful speaker with us today. Her name is Swagateeka Lenka, and she is in the DMCA team, which will take the session forward today to give us more insight about how to deal with this kind of takedown notice which comes against you and they are false in nature. So over to you, Swagatika, and you can continue with this session. Thank you.
Thank you for the introduction, sir. Good afternoon, everyone. So, as Sir said, today's topic of discussion is if you have received a DMCA takedown notice or there is a DMCA takedown notice against you, how to deal with it. Firstly, the internet world or the online platform is booming like anything. So, if you're a website owner, then you might receive a DMCA takedown notice or your content might be removed because of a DMCA takedown notice. If you're receiving a DMCA takedown notice, that doesn't always mean that that notice has merits. It can be a fake notice. It can be a notice which is not having any ground on it. In such kind of situations, what remedy you have or what you can do, we are going to discuss about it today. So there can be situations where you, being a website owner, your content has been copied by someone else, and that other party is sending you a DMCA notice or a takedown notice. Or there can be situations that you're not infringing anyone's right, but still you're receiving a DMCA takedown notice. So in such a situation, there is nothing to panic. If you have a valid copyright, or if you have a reasonable ground or to prove that the content that has been removed because of the DMCA takedown notice, then you have a remedy with you. And that remedy is a counter notice which can be filed by you. Now, what is a counter claim or a counter notification? So, counter notification is a legal remedy which you have to object the DMCA takedown that has happened because of the DMCA takedown notice of the copyright holder or of the complainant. Now, a copyright holder can send you a DMCA takedown notice if he finds that there is some material available in the online platform that is infringing his right. Now, he can send a notice to the internet service provider or the online service provider. Now, the online service provider, after receiving the notice, he will expeditiously take down the content to get the benefit of the safe harbor provision, that is section 512 of DMCA. Now, the internet service provider will not go in depth to the merit of the case or the merit of the complaint and see that whether there is a proper infringement or not. It will only see that the DMCA notice is having all the valid points that is essential or that is required, and based on it, it will remove the content after receiving a DMCA takedown notice. Now, after your content has been removed, you can send a counter claim to the online service provider to if you have a valid claim. Now, why a counter claim? As I said, there can be situations where you being a website owner and you have a content that is your own content and you have not copied anyone else's content, but the other party has copied your content and is sending you a DMCA notice. That is quite unfair on your part. Or there can be situations that you are posting something online and that is falling under fair use. That can be also situations that you are not infringing anyone's right and you're still getting a DMCA takedown notice. In such kind of situations, you can send a DMCA counterclaim notice to the online service provider stating the reasons why you feel that you are not infringing anyone's right. It can be fair use, it can be that you are a copyright owner of that content, or it can be that the DMCA notice is fake or erroneous. There can be various situations. And if you believe that there is reason to prove or reason to believe that you're not infringing anyone's right, then you can send a counterclaim notice. Now, who can file a counterclaim notice? You, being a website owner, against whom or whose content has been removed, can file a counterclaim, or the person who is receiving a DMCA takedown notification can also file a counterclaim against the takedown notice. Now, when a service provider is sending you a counterclaim notice, generally, along with the notification only, the service provider provides the instruction how to file a counterclaim notice. Because as I said, the service provider, when it receives a takedown notice, it will not go into the complaint in depth, or it will not decide the legal part of that complaint. It will only see that the DMCA notice is fulfilling all the points that is required under section 512C of DMCA Act, and based on it, it will remove the content or alleged content to get the benefit of the safe harbor provision. Now, also it will be sending you the notice of that, or a notice that has been sent by the copyright holder or the complainant, and it will notify you that there has been a DMCA takedown notice against you, and it will also provide you the instructions, or it will also provide you how to file a counterclaim. Generally, when we file a takedown in Amazon, the Amazon also sends a link where you can file a counterclaim. Now, either it will send you the link, or it will send you the instruction how to file a takedown notice. If you have not got any instruction from the service provider, or if the service provider has not provided in any link or place where you need to go and file a DMCA counterclaim, in such a situation, you can also draft a DMCA counterclaim notice fulfilling all the essential conditions that is required. Since a DMCA drafting a DMCA counterclaim notice is a tricky thing, it is always advisable to take help of a legal expert to draft a DMCA counterclaim notice. Now, coming to the next slide. What are the essential requirements for a valid counterclaim? As I said, the counterclaim notice has to fulfill certain valid requirements. A counterclaim notice has to fulfill certain valid requirements. So firstly, in drafting a notice, the very essential element of that notice will be you need to identify the removed material. Now, what is the meaning of this removed material? The removed material means the material that is an issue, or the material against whom a complaint has been filed by the copyright holder or the complainant, and on the basis of the complaint, the service provider has removed that material. Now, you need to identify that removed material. Now, how will you identify that removed material? It can be being a website owner or being the content owner. If you have a copy of that content in your Google Drive or in your laptop or in your system, you can substantiate your claim by providing the service provider with a copy of that material. Now, the location of the removed material. Now, what do you mean by the location of the removed material? Location means the place where the content was posted before it was removed. Let me cite an example for it. For example, you being a seller in Amazon, you have a posting in Amazon.com. Now, because of a DMCA takedown notice, your posting has been removed. Now, the location of the removed material means the place where the content was originally posted. You need to provide a URL of that. Even though the content has been removed, you need to provide a URL of the place where the content was originally posted. Now, description of ownership. What is the description of ownership? when you are filing a counter notice, you have to substantiate that notice with valid claim why you feel that you are not infringing anyone's right, or why you feel that the content, the removal of the content is not valid, or in good faith you believe that the content has been removed because of a mistake, or because of a misidentification, or because of any fake DMCA notice. Now you need to describe how you own that content. If you have registered your copyright material, you need to provide you the certificate along with it. Or if you have any valid documents to substantiate your claim, you can provide it to the service provider along with uh, a counterclaim notice. In such way, the service provider can evaluate the notice properly. Now, a statement of good faith. What do you mean by statement of good faith? In the notice, you have to state that whatever information you are giving, whatever documents you have given to substantiate your claim, you have given it in good faith, and in good faith, you have a reason to believe that whatever the content that is removed is because of a mistake, or because of a misidentification of the content, and you have not infringed anyone's copyright. So you need to give a statement in good faith. Along with that, you need to provide your contact details and the signature. Now, if you are sending the notice to an agent, you need to provide the contact details of the agent or the signature of the agent. Now, coming to the next slide, who can receive a DMCA counterclaim, or to whom you can send a DMCA counterclaim? First, social media platform. Social media platform means Facebook, TikTok, Instagram. Now, in this kind of platform, generally there is an infringement that happens, or when this kind of platform sends you a copyright notice, they also send a form along with it. In that form, they're saying that if you have any counterclaim, you can fill that form, or you can send us a notice along with the instruction that is provided in the mail. Then you can follow the instruction, we can draft a notice and we can send to the social media platform. Now the social media platform will evaluate that notice and will act accordingly. Now, e-commerce platform. E-commerce platform means Amazon, eBay, Shopify, all these e-commerce platform or the shopping websites. This fall under e-commerce platform. Now, the e-commerce platform also generally sends instruction along with a form link where you need to go and file a counterclaim. As I said, it is always advisable to consult a legal expert before filing a DMCA counterclaim notice. Internet, or you can also send your DMCA counterclaim notice to the internet service provider and also to the website owner. Now also, internet service provider, they also provide you an instruction how to file it. If they have not provided even an instruction, then we can draft a legal notice following the essential requirements that we discussed just before it, and then we can send it to the designated internet service provider's address. Now, after we send a counterclaim to the internet service provider or the service provider. The service provider will forward that counterclaim to the complainant or to the copyright holder who has filed a DMCA takedown notice. Now, after we send a notice, the service provider will wait for generally 10 to 14 days to see if there is any objection from the complainant or from the copyright holder who has filed a DMCA notice. If there is no objection that is raised by the complainant or the DMCA or the copyright holder, then it will reinstate your content or it will re-enable the access to that content. But if there is an objection, then objection can be from the copyright holder in form of a court notice to stay, or it can be a court notice. Now, what things you have to keep in mind while sending a counterclaim? As I said, sending a counterclaim notice is a legal thing. You cannot just send a counterclaim notice if you know that you are infringing someone's right. If you are doing that, then it can give rise to various complex situations, like there can be a penalty, there can be a civil or criminal liability against you. you have to pay damages. There can be various complex situations. So the first and foremost thing you have to keep in mind while sending a counter notification is that you are sending that notice in good faith. Good faith here means that you have a strong belief or you have proof to substantiate your claim that you're not infringing anyone's right. If you are actually infringing someone's right, then it is always advisable to take down that infringing content or remove that content from your website. But if you're not infringing anyone's right, and there is a fake DMCA notice to hamper your reputation and your business, then counterclaim will always come to your rescue. So it is always advisable that you have a good faith, and second, you have a rightful claim. Now here rightful claim means, for example, you are an owner of a copyrighted work. Let's say you are owner of a blog. You have copyright copyright on your work. You have a copyright registration for it also. Then you have a rightful claim. You can also substantiate your claim by giving a copyright registration certificate. In such a case, there can be no legal. You have a higher chance of getting a relief. But if you don't have any rightful claim on it, you yourself know that you're infringing someone's right, but still you are sending a counterclaim notice to the other party. In such a situation, the other party will naturally come or naturally take help of a court and send you a court notice. Now, once sending a court notice can be quite expensive on your part, and you can also be liable to pay damages. Now, investigate. What investigate means? Investigate here means that if you're not sure whether you have a copyright on it or not. For example, if a case is falling under fair use and you're not sure whether there is a fair use, whether you're infringing someone's right, whether you're not infringing someone's right, then it is always advisable to take help of legal expert to guide you on this matter. Now, when you go to a legal expert, they will look into various factors, like what subject matter that is, or what is the matter in issue, how much you have copied, whether the thing that you have copied is falling under fair use or not, whether you have a rightful claim on it or not, whether it is an erroneous complaint. All these factors the legal expert will consider, and then they will advise you whether you should go for a counterclaim or you should not go for a counterclaim. Now, penalties. As I said, if you don't have any right, or if you don't have a rightful claim and you're filing a copyright notice, then you have to pay penalties for it. That you can be civil, you can be liable civil or criminally. Now, also you need to have a clear idea about the copyright laws. Now, how to get an idea about a copyright law for a common man? You need to always take help of a legal expert whenever any copyright issue comes into play, because only a legal expert can guide you properly in case of infringement, or in case you receive a DMCA takedown notice, whether you should go for a counterclaim or you should not go for a counterclaim. Because sending a counterclaim notice can sometimes be very risky, or sometimes work against you, because then you have to pay a higher price for it. Instead of getting a remedy, you will be dragged into legal consequences because of a wrong claim that you are claiming. So I hope this presentation is helpful to you and you have got some idea about counterclaim. Now, if you have any questions, you can put it and I will try my best to answer your questions. Am I audible?
So let me check if there is any question. Okay, so one small query before I ask some question, or maybe you can answer that. How many times we can file a counterclaim? Is there any such restriction? And or is there any such legal rule that we have if we can go on filing counter notice, or should we? So, how is the timeline? If you can give some
Yes, that
information.
is. Firstly, there is no timeline mentioned, like within how many days you can file a counterclaim, DMCA counterclaim notice. But it is always advisable to file a DMCA counterclaim notice as soon as possible. If you feel that there is a rightful claim and in good faith you believe that there are reasons to file a counterclaim notice. Now, the second question that you asked is how many times we can file a counterclaim. So as I said, when you are filing a counterclaim, the service provider will forward that counterclaim to the person who has or the that forward a counterclaim to that original copyright holder or the complainant. Now, if the complainant is the real owner, or if a complainant is having a strong case, it will anyway oppose your counterclaim and send you a court notice, or to state that, or can send you a court notice to go to the court and fight the case. Now, how many times you can file a counterclaim? As I said, if the other party is not responding, or if the other party is not putting any kind of opposition to your counterclaim, then the service provider will automatically reinstate or re-enable your content to the original place where it was originally posted. So I think that is answering your question.
Yes. So there are two questions which we are going to take. One is, how many days does it take to get back a takedown page or a video?
Okay. So if you're sending it to Amazon, Amazon generally takes down the content within 24 to 48 hours. Now, if you're sending it to any e-commerce website, they generally act on DMCA takedown notice within 24 to 48 hours. Now, if you're sending a notice to Facebook or any social media website, they also take the action expeditiously to get the immunity from the, or to get the immunity of section 512. So generally you can take 24 to 48 hours, but if you're sending it to some individual website, then it may take longer, but not longer than 7 days. So within 7 days, if you have a valid claim, then there is a takedown.
Okay. There's one more question. Whom to send a takedown notice if someone copies your content on Instagram?
On
Instagram.
Okay. So if your content has been copied on Instagram, now Instagram is a platform. So they have a very well-founded DMCA complaint mechanism, or where you can go and file a complaint. They have a strong DMCA complaint form where you need to go and file a complaint. Now also you can draft a complaint with all essential requirements that is mentioned. You can take help of a legal expert. We are there to help you. If you can take help of legal expert, draft a valid notice and send to the contact detail that is provided on the Instagram page. They have a very well-founded DMCA takedown policy.
Okay. With that, I think today we come to an end of the session. So thank you everyone for joining the session and going through it. If there is any question, you can get back to us on our LinkedIn profile and ask any questions you have, or please visit to LexDMCA.com for more information about our services. Thank you. Thank you for joining.
Thank you.